You are listening to Labor Pains, an Injured Worker podcast featuring conversations in workers' compensation and health and safety in Ontario, Canada, and beyond. Labor Pains is produced by Injured Workers Community Legal Clinic and is not a substitute for legal advice. For more information on workers' compensation issues, campaigns, and resources, visit injuredworkersonline.org. Today's episode is hosted by Tabassum Durrani, a lawyer at Injured Workers Community Legal Aid Clinic.
In today's episode, we're examining a little-known but deeply consequential policy, the Workplace Safety and Insurance Act's cutoff of wage loss benefits at the age of 65. Now, on paper, it might sound like just another administrative rule, but in practice, it raises serious questions about age discrimination, economic security, and fairness for injured workers, particularly older workers who are still part of the workforce. I'll be speaking with legal experts Chris Grawey and John McKinnon from our legal clinic, Injured Workers Community Legal Clinic, who are challenging this law and making the case that it's not just unfair, but potentially unconstitutional.
Thank you, John and Chris, for joining me.
Thanks for having us.
Yeah, thank you, Tabassum.
Can you start by explaining what the WSIB's policy is when it comes to cutting off loss of earnings benefits when someone reaches age 65?
Well, sure. It's all tied around age 65. If a person is injured up until age 63 and they have a permanent impairment and they're not able to go back to their old job, and so they have a loss of earnings and they're getting compensation for loss of earnings, that compensation will stop when they reach age 65, regardless of when they might have continued working to. For workers who are 63 years of age or older, and in the same situation, they have a serious injury, they have a permanent impairment, they can't do their old job, they're losing their income. If they're 63 or older, they can only get compensation for those lost earnings for 2 years. And then it ends again, regardless of their circumstances, whether they needed or intended to continue working on. So those are the main limits. There are a couple of other limits. For example, for most workers, if they're injured on the job and they recover to the point they're able to go back to their old job, the employer has to keep that job open for them for 2 years after the injury in case they are able to come back and pick up where they left off. But that doesn't apply if you're age 65 or older and you're hurt. Your employer can bring in someone else the next day and you might be ready to come back in a month or a year, but the employer is not obligated to give you your old job back, even if you make a full recovery. So that's one of the other problems. And then there's the compensation for loss of retirement income. If a worker does have a permanent injury and they're getting compensation for their lost earnings, there's something that's set aside for the loss of retirement income. But again, that doesn't apply to workers that are hurt at age 65 or older, even if they can get the 2 years of compensation benefits for lost earnings. There's no contribution for their loss of retirement income. And of course, otherwise, normally, if you were working, you'd be paying into the Canada Pension Plan, you'd be paying taxes for your old age security. But so those are the main limits around age 65.
So what assumptions is the current legislative scheme relating to benefits up to the age of 65 based on when it comes to retirement age or working patterns? And how do these assumptions hold up in the context of today's workforce realities?
So I think I'll take that question. So the assumption about retirement is an outdated one. So at the time when the legislation was first introduced, people typically retired at age 65 because there's mandatory retirement in the province. But gradually over time, that was challenged, and it was found to be, discrimination based off of age. And as a result, the retirement age in Ontario was eliminated, I believe, in the mid 2000s. And perhaps, John, you can provide the exact year. But yeah, based off of the fact that people were living longer, people were, either voluntarily wanting to work longer or needed to because of financial circumstances. It just wasn't fitting in with, I guess, current assumptions in society. And if we're looking at like statistics about demographics of the workforce, it is skewing older and older over time. Um, and again, like some people choose to work out of necessity because, their workplace may not provide a pension for them, or they're in a low income job. So that's kind of one category. The other category is people voluntarily wanting to continue to work because either they like it, or just they want to continue to perform some type of labor that they find personally, I guess, fulfilling. So yeah, the assumptions are kind of out of whack with the current trend in the workforce. And that's one of our arguments as to why the legislation at the WSIB does need to be amended by the government.
So on that note of needed amendments and changes, Injured Workers Community Legal Clinic, alongside other organizations, has taken the view that the current legislative section that governs these rules is unconstitutional. Can you explain how, in your view, the provisions in the legislation violate the Charter, specifically Section 15?
Well, sure. As Chris mentioned, it used to be allowed that mandatory retirement at age 65. An employer could just let people go at age 65, and there's nothing they could do about it. And as Chris mentioned, it was in 2007 that the Human Rights Code was amended to prohibit that. But the WSIB asked for and received a special exemption from the Human Rights Code because they said, well, it's really complicated to change this, and you want to change the Human Rights Code right away, and we can't do that, and we don't know if we can afford it either. So there certainly was a lot of debate about that, and in fact, the Ontario Human Rights Commission filed a written submission against the WSIB's request for an exemption, saying, no, this is age discrimination in its worst form, and you have to change. Unfortunately, that wasn't accepted by the government. So since they're exempt from the Human Rights Code, all we have to argue is the Canadian Charter of Rights and Freedoms. And as you mentioned, under Section 15, it prohibits discrimination on the basis of a number of grounds, including age. So clearly, this law does discriminate on the basis of age. It ends benefits based on age 65. But the Charter of Rights does allow discrimination if it can be justified as being reasonably necessary under the circumstances. And so that's the real issue, is whether this can still be justifiable. And so there was an earlier challenge to this provision back, I mentioned the Human Rights Code changed in 2007. 2009, an injured worker took this issue to the Workers' Compensation Appeals Tribunal, arguing that this is discrimination, and the case moved on to the Ontario courts, and in the end, the divisional court said, yes, this is discrimination on the basis of age, but it can be reasonably justified because, in fact, most people have retired from the workforce before age 65. And since this is, it's a wage loss system, it's not a pension for life system, it has to end at some point when you can say is the reasonable end of a person's working life. And since statistically the majority of people were not in the workforce and were retiring before age 65, they said that's a reasonable point to draw the line. We think things have changed, and as Chris mentioned, there's a much higher incidence of participation in the workforce. And so we think it's time to bring this issue forward again and take another look at it.
So I wonder if you can give our listeners some examples of how this law works in practice, in a way that can perhaps illustrate the harm that you feel comes out of this kind of increasingly arbitrary cutoff.
Right. So I can speak to a few of my clients' specific circumstances, and then some other older injured workers that I've spoken with about their issues. So there's a few different kind of scenarios that can play out. So as John mentioned, the LOE, loss of earning benefits, terminate at age 65 if you're injured when you are below the age of 63. So I was speaking with a nurse last week, and she was injured when she was 61 years of age, and the WSIB was providing her wage loss benefits. But because of the way the law is written, the WSIB cut her benefits off when she turned 65. However, when she was expressing her circumstances and her story to me, she indicated that her intent was not to retire until the age of 70, because but for the injury, she was in relatively good health. She enjoyed her job. She found it, personally fulfilling. It met her income and financial needs. But as a result of the way the law is outlined, she now loses out on 5 years of wage loss benefits. So this has a, directly and immediately negative impact on her overall financial circumstances. So that's one, typical situation that arises, is when people are injured below the age of 63, when they're permanently injured, unable to go back to work, they just get cut off at 65, regardless of whether they plan to retire or not. Another common example relates to the other part of the law, in which if someone is injured when they're 63 years of age or older, they can only get loss of earning benefits from the WSIB for a maximum of 2 years. So I've had workers aged 64, 66, 68. They get injured. WSIB accepts their claim. They provide healthcare treatments. They provide loss of earning benefits. But the loss of earning benefits are terminated 2 years after the date of injury. So if someone was injured on, at the age of 66, say June 18th, 2023, their benefits, loss of earning benefits, would expire June 18th, 2025. Now, what's also kind of hypocritical or contradictory about the way the law is written is that they can continue to get other benefits from the WSIB, even though their wage loss benefits are cut off. So one of my clients had surgery, was receiving prescription medication coverage, and going for rehab treatments. That all continued beyond that 2-year limit. It's just the wage loss benefits that were cut off. With another client, again, he was injured when he was 66 or 67 years old, and he was in a graduated return to work process, meaning that, he was working 2 hours for 2 weeks, 4 hours for 2 weeks, etc., until he returned to 8 hours full-time per day. Now, in the middle of that graduated return to work, the 2-year limit had expired. So the WSIB was topping up his wages. So when he was working for only 2 hours per week, the WSIB was topping him up 85% of the additional 6 hours. Now, when he was working 4 hours per week, the WSIB cut off the top up because it was 2 years post-accident. So for the remainder of that graduated return to work, he had no income from the WSIB, even though they were directly involved in the return to work process with the employer. The employer took the position that it's not their obligation to top up because it was a work-related injury. So my client is in this kind of limbo area where, it's accepted he has a workplace injury, he's getting benefits, the employer's not objecting to any of this, but no one wants to pay him once that 2-year age limit occurred. Another common situation is when, someone's injured, let's say at age, 61, all right? They do experience a period of wage loss, but they do get back to work full time. And, when they're, say, 68 years of age, their condition might, naturally deteriorate without a new accident occurring, or they might require a surgery for that work-related injury. The WSIB, again, will cover any sort of healthcare treatments and costs related to rehab, prescription medications. But if that person is still in the workforce and they need time off because of a surgery, the WSIB will not pay them their wage loss benefits because they were injured under the age of 63. So the latest that they could receive loss of earning benefits would be age 65. And because they're now 68, they're not entitled to those benefits. So those are some of the, I'd say more common types of situations that arise. But there can be, combinations of multiple factors that are even more egregious, but those are, I'd say, the ones that typically we come across in our work from day to day.
That was really helpful in making clear how this works in practice and impacts workers. So you've told us that more and more Canadians are working well beyond the age of 65, and that there are these scenarios that workers find themselves in where they are cut off from various benefits and supports. I guess the question now is what should be done? What's the fix or reform that you as advocates are looking for from the WSIB?
Well, we need to change the legislation to provide compensation for lost earnings if people get injured or ill as a result of their job. And more people are working well past age 65. And so we need to do something about that. Workers' compensation was actually the very first social program implemented in Canada. It's based on each province, but and it was based on the principle that there should be compensation for as long as the disability lasts. And so people are working past age 65, they're losing income if they're injured on the job, and they should be compensated for that. So we need to change the legislation. And of course, now all the Canadian provinces have outlawed mandatory retirement. They've all changed so that people can continue working past age 65. And a number of provinces have arranged for a workaround in order to deal with the unfairness of the sort of the old age 65 based cutoffs in workers' compensation. One of them in British Columbia involves allowing the worker to present evidence that they would have continued to work beyond age 65. Maybe that's the practice in their workplace. Maybe it's the practice in their union. Maybe they've got a mortgage that they've negotiated to age 70 or whatever. So there's a number of ways that workers there can show that they intended to work beyond age 65, and very similar provisions in Alberta as well. They have a provision that a worker can present information that shows that they were going to continue working beyond age 65. But another protection in Alberta is that they've said that if you're injured at age 65 or older, it's going to be presumed you would have worked for another 5 years. So if you're injured at age 68, you will get compensation for your lost earnings for 5 years up until age 73 and so on. And that is certainly a good step forward towards addressing the wage loss for older workers. The statistics on workplace injuries for workers age 65 and older are skyrocketing because the number of older workers in the workforce is skyrocketing, and it's only fair and just that we do something about that.
So some may counter argue that making this change would be too costly or expensive for the WSIB. How would you respond to that concern?
I would say it's not a concern at all. I'm sure, those of us in Ontario, at least, who pay close attention to like workers' compensation, WSIB related issues, are well aware of the fact that the WSIB is essentially like flush with cash. And, one of the main reasons why that is because workers historically have been undercompensated through a variety of means, such as reducing the loss of earnings percentage that workers can be entitled to. But, in recent years, since the Doug Ford provincial government was elected, premium rates for employers, those have been slashed. So just as a quick kind of background, WSIB is funded through employer premiums and investment income, and then any penalties that might be levied by the board. So it's not like workers don't contribute to WSIB, nor does the government. But with that being said, since the Conservatives came to power in, I think, 2018, the average premium rate per $100 of insurable earnings has like dropped like significantly. I think it was at $2.35 when the Conservatives were elected, and now it's down to $1.25. So that's about $1.10 difference in less than 10 years. So that's like unprecedented. And the government did brag about in one of their press releases the fact that the premium rates were at the lowest level in half a century, which is absurd considering what other type of program, government, private sector, or hybrid, are costs reduced in that manner in such a short time frame. So that's, the one point that's important to note. The other is that the government's also been gifting corporations billions of dollars as part of this so-called surplus. So I think it was in November of 2024, the government announced that there's going to be another round of distribution of $2 billion to employers. And then because of Trump's threats related to tariffs in March or April of this year, they announced another $2 billion. So the government stated that since they've been in power, the cumulative savings to employers is more than $20 billion. So like that's an excessive amount of money. And it really just amounts to a transfer of wealth from working people to big business and corporations that are making record profits at this time. So like, I guess to cut it short, like the WSIB's financial position is, more than stable. And in fact, this is one of many changes the government could easily make that would, directly improve the lives of injured workers. And I think one other point we should make note is that there should be retroactivity included as well, because there's been workers for, over 25 years that have been negatively impacted by the age cutoff provision, there's more than enough money to properly compensate all of these people, considering how the WSIB is currently funded. So there shouldn't be really any kind of fear-mongering from the WSIB at all. If they try to do that, we know it's completely manufactured and outright lies. Injured workers have borne the brunt of bad legislation, bad policy, and bad adjudication for a number of years. So it's, I guess, high time that, the government implemented positive changes on a universal basis for injured workers.
Okay. Well, thank you both for joining. Oh, sorry.
Well, just building on Chris's point, in 1997, the government introduced cuts to workers' compensation benefits based on a concern that the workers' compensation system was in financial difficulty. And so they said everyone needs to tighten their belts. And so they reduced the benefit levels for compensation from 90% of your take-home pay to 85%. They also reduced the amount of money they set aside for the loss of retirement income. It was 10%, and they cut that in half to 5%. So those cuts are still in place, but we're now in a situation where the WSIB is overfunded. When the WSIB has 100% of its funding, that means it has enough money in the bank now to pay out every injured worker on the books to the end of their lives. And the WSIB, when it reaches 120% funding, it's allowed to start giving money back to employers. And so that's what's been going on. In the last 3 years, $5.7 billion has been returned to employers on the basis that there's a surplus in the system. But we can see that, in fact, the only reason there's a surplus now is because they're not compensating everyone who gets injured and ill and loses their income. And so that's what we need to see. The employers' rates are at record low, and still the WSIB has record high surpluses, and that needs to be directed to injured workers.
Thank you both for joining me.
You have been listening to Labor Pains, an Injured Worker podcast, produced by Injured Workers Community Legal Aid Clinic. Labor Pains is not a substitute for legal advice. For more information on workers' compensation issues, campaigns, and resources, visit injuredworkersonline.org.